story of a case. TOURNIER versus National Provincial and Union Bank of England 1924 was a landmark legal case in the United Kingdom. The lead decision was given by banker LJ. In this case, the bank disclosed to its customers employer that fact that one of the customers' unpaid check was thrown in favor of bookmaker's account. The story of a bank, the National Provision. National Provision Bank was a British retail bank which operated in England and was from 1833 until 1970 when it was merged into the National Westminster Bank. The National Provision Bank playing a unique role in the development of commercial banking. Prior to the Act of 1826, the first branch to be opened at the beginning of 1834 was in Gloucester, followed as if at random by Brecon, Walsall, Birmingham, Morton under Egg, Boston, and Whitby, and by 1836 there were 32 branches. Union Bank of England. The Union Bank of England Bank has been operating from the City of London since 1983, firstly as the London branch of the parent bank and since October 2004 as an independently incorporated UK bank. Received authorization from the Financial Service Authority, known now as the UK Financial Conduct Authority.
Second is issues related to banking operation. The plaintiff was a customer of the defendant bank. A check was drawn by another customer of the defendant in favor of the plaintiff, who instead of paying it into his own account endorsed it to a third person who had an account at another bank. On the return of the check to the defendant, their manager inquired of the last-named bank who the person was to whom it had been paid, and was told it was a bookmaker. That information the defendants disclosed to third person.
Okay, now I will explain about the right and duties of customers. So customers have the right to privacy, which means they have the right to have their accounts information confidential. All the personal information, account and balance must be kept confidential. Bankers cannot reveal the details of their customers to anybody. They can only do that when it is required by law or after the customers have given their consent. Okay, the duty of customers. Customers can sue bank for wrongful disclosure of his or her account, balance or information. The customers of a bank may be entitled to claim for damages if he or she has suffered losses due to the bank breaches its duty of secrecy. Okay, now is the right and duties of banker. So banker has the duty of secrecy. Secrecy of customer's account must be strictly observed with the exception of certain instances where information can be revealed. Section 133(1) of the Financial Services Act stated that a bank, including officer, owes the duty of secrecy to its customer and cannot disclose their account information even though the account has been closed, unless with customer's consent expressed or implied. There are 4 circumstances whereby bank can reveal customer's information. First is disclosure under compulsion of law. Second, disclosure is required in the public interest. Third, disclosure in the interest of the banks. And fourth, express and implied consent of customer.
The principle is a bank is a financial institution that is allowed to accept deposits and make loans. According to Section 2 of the Financial Services Act 2013, a bank is a person who carry out a banking business of asset deposit in any currency or deposit account, paying and gathering checks by the clients, offering advances and loan to client, and any provisions as permitted by the Ministry of Finance. Banking secrecy is a conditional arrangement between a bank and its customer that all of the above activities remain safe, private, and confidential. The bankers owes its customer a duty of confidentiality at all times, as well as obligation to maintain confidential details about the affairs of its customers. Based on Section 1331 FSA 2013, provides that all officers of licensed institutions are under a legal obligations to keep secrets of affairs of its customers. In these situations, the court held was the bank admitted to the employer of its customer that one of the customer's outstanding checks was drawn in favor of the account of a bookmaker. As a consequence, the employer of the firm decided not to renew his contract with the clients. The Court of Appeal held that confidentiality is an implicit concept in the agreement of the customer and that if loss occurs, any violation may give rise to liability for damages.
For the lesson learned, A banker is responsible to have the duty of secrecy to its customer at all times, which also includes the duty of keeping customers' information confidential. It's known as a contractual in nature. This has been stated in sections 133, subsections 1 of the Financial Act 2013, as well as in the Banking and Financial Act Institution Act 1989, via Part 13, Information and Secrecy, sections 97, subsections 1. Customer may be entitled to claim for damages when there is a breach of duty by the banker. The circumstances where bank can reveal customers' information to the third party is by court order, required in the public interest of bank, and by express and implied consent of the customer.
Lastly, is the right alternative should be done by both parties. Section 133 FSA 2013 provides that all officers of licensed institutions are under a legal obligation to keep secret the affairs of its customer. The plaintiff brought the suit first for defamation and secondly for violation of an implicit arrangement that the defendant does not reveal to third parties the status of the account of the plaintiff or any transactions relating thereto. TOURNIER sued both for defamation and for breach of contract. The Court of Health ruled that a banker owes a moral commitment of secrecy to his client not to reveal details to third parties, and that any violation of that obligation could give rise to liability for damages in the case of a failure. As a result, if a banker violates his duty of confidentiality, the client might be entitled to seek damages. Thank you.